Lord Woolman, good morning. How are
Good
you?
morning. I'm in top form.
You're in top form. Well, that's fantastic. Well, thank you so much for taking the time to join me on Hey Legal. I'm very much looking forward to our chat today. Much to cover. We are going to talk about your role within the tribunal system in Scotland. We have a very wide and varied audience that listens to and views the content that we have. So I wonder if you could just start, Lord Bowman, please, by giving a brief outline of what the tribunal system in Scotland does and your role in it, please.
So, the Tribunals Scotland Act 2014 created a new tribunal structure with a first tier tribunal and an upper tribunal, and it's expanded since then. The aim of the new scheme was to create a more cohesive structure of governance and operations. But the key to the success of the tribunal reforms is maintaining the specialist nature of each tribunal. At present, there are 5 chambers. Let me just go through them. First, housing and property. It deals with disputes between landlords and tenants. Second, health and education. It looks at additional support needs in schools. Next, third, social security. It deals with all questions of child payment, child disability, funeral support, and the like. Then there's the General Regulatory Chamber, which deals with charity appeals, parking, and bus lane appeals. Fifth, there's tax, which deals with lands and buildings transaction tax, and in particular Scottish landfill tax. But there are expansion plans. The first tier will expand next year with the creation of a local taxation chamber, which will deal with non-domestic rates cases. And the current Mental Health Tribunal for Scotland will transfer into the tribunal structure. I should also mention that there'll be a huge increase in social security cases when the new adult disability payment comes into force. The projection is as much as 25,000 cases a year. Now, if I might just say something about the membership, the idea is that the Scottish tribunals are specialist chambers. The members have particular expertise in the jurisdictions in which they preside. Let's take 2 examples. There are surveyors in the Housing and Property Chamber, and in the Social Security Chamber there are medical members. In every chamber there are legal members who have relevant experience in the area of work with which that tribunal is concerned. Now, my role as the president of the tribunals is to represent and promote the interests of the Scottish tribunals, working with the chamber presidents. I might say this, Sally, we have coffee and donuts on the last Friday of each month, just half an hour, that we try and chat about matters of common interest and perhaps also talk about the latest TV series on Netflix. But more formally, the Lord President has delegated authority to me for the efficient disposal of business in the tribunals and to consider and look after the welfare of the tribunal members. That involves us liaising with the Scottish Government and others to ensure that we have the right number and quality of tribunals judiciary, that the right rules of procedure are in place, and that any proposed reforms are prepared and scrutinised thoroughly. I hope that's not too long an answer.
No, that's perfect. That's a great structured response to my question and works really well. So, can I ask? Obviously, every aspect of the justice system was rocked by the pandemic. Can I ask in specific, what was the impact of the pandemic on the tribunal system?
Well, as you say, Ali, from March 2020 onwards, COVID-19 has caused twists and turns in the administration of justice. The Scottish tribunals have responded magnificently. The chamber presidents have been agile. I know that's a term which has come into more common currency recently. The members have been committed. In short, we have delivered. That's been vital to individuals in a time of anxiety and sometimes crisis. Would it be all right if I was to say something a bit more detailed about this?
Of course, please do, Lord Woolman, please do.
So when the pandemic hit, members and staff switched quickly and effectively to new ways of working. Most tribunals had to close their doors initially and only provided a minimal service. As lockdown eased, there was a gradual return to service and the reduction and clearing of backlogs. Indeed, I can say today that there are no backlogs in the tribunal system. Let me select the Mental Health Tribunal for Scotland as an example. It received the highest number of applications in its history. The swift introduction of virtual hearings, primarily by means of telephone conference, meant that it achieved its statutory targets in every case, with 5,300 hearings conducted. So, how did we achieve this? Well, members were deployed flexibly. One advantage of technology is that we were able to hold hearings without geographical constraints. Tribunal clerks facilitated hearings from their homes. Digital systems were adapted and improved to support remote working. Chambers greatly reduced their use of hard copy documents. So panels continued to hear cases, but perhaps more importantly, the feedback was positive. Users appreciated that the tribunals were maintaining access to justice. Many found that the virtual hearings were better than they had expected. That's my answer to that particular question.
No, it's incredible to hear that, and it's something that has obviously happened, in other parts of the justice system. And really, I suppose what we have seen is something that may have taken, I'm going to say, a decade. It may have taken decades for some of these practices to be implemented, but suddenly through necessity, they were required, and then people are testing them in real time and making them work.
I agree, and it provides a smorgasbord in which one hearing might suit a telephone conference call, another might suit everything done by means of correspondence, and others justify in-person hearings because that gives texture to that particular dispute or claim.
Yes. So that leads us on, I think, to the next phase of this, which is that having had the seismic jolt of the pandemic, and while we're no means beyond all of that, we're probably now in a phase where systems are having to be implemented that can gain some insight from what happened during that 18-month period or so, and now we look to the future. Now, I noted in the conference that took place in September that you had outlined that the word tribunals derives from the tribunes of ancient Rome, which had the same important role, which is to uphold the rights of individuals. So going forward, how does the tribunal system best uphold the rights of individuals? How do we find the sweet spot in deploying remote and in-person hearings?
Well, I think the first point to make is that it's not a case of one size fits all. Each chamber president is monitoring, carrying out an audit of his or her own chamber to see what looks best for individual hearings. And obviously the needs of the mental health tribunal, for example, which is about a vulnerable individual's liberty, health and safety, can be very different from a dispute about a parking fine. Parking fine cases were, even before the pandemic, almost always dealt with by means of remote correspondence and perhaps a short telephone hearing. But in mental health cases, they are more likely to require in-person hearings, and Laura Dunlop QC is currently overseeing a carefully prepared and phased return to in-person hearings. So the short point is that each chamber is learning the lessons from the pandemic to develop its own approach. There's no doubt that there will be continued use of hearings by means of video conference and by telephone as options, if that is suitable for the case. I think the broad change may come in relation to procedural hearings. It's likely that they'll all be largely remotely held so that people don't need to go to a particular office or place or court or tribunal room. They'll be able to deal with them from their own office or home. And it may be that tribunals in this respect have more flexibility than courts, because traditionally we've adopted a more flexible, informal attitude to cases.
Yeah. I suppose what it requires is, maybe like everything, it requires emotionally intelligent leadership from those who are trying to implement the systems. Because as you say, some disputes of a fairly, perfunctory nature would lend themselves very readily and already do to just remote hearings, very limited actual human interaction within them. Yet at the other end of the scale, a person's liberty being at issue in relation to a mental health tribunal, just requires a completely different type of approach.
I think we encourage, and the presidents encourage, the individual tribunal to look carefully at what will suit the needs of that case and that applicant, that claimant best. And I think, to sum up, the tribunals provide an incredibly important part of the administration of justice, and that it's often a neglected part, but for citizens, it may be the most valuable part.
Well, thank you. Can I just ask, how did you come to become a High Court judge, I suppose, and find yourself in this particular role?
Well, there's two separate questions there. In respect of becoming a High Court judge, I'd spent time, many years, at the junior and then the senior bar, and I applied to the Judicial Appointments Board for selection as a High Court judge. And I felt it would open a new chapter in my professional career. As to becoming the president of the Scottish Tribunals, when I was appointed to the Inner House, essentially the Lord President invited me to become the president of the Scottish Tribunals.
Is that an invitation that you have to say, you must say yes to?
Well, it didn't take me long to say yes.
Yes, okay. And when we're lucky enough to have esteemed guests such as yourself, Lord Woolman, we always like to ask some extra questions. Is that okay with you?
Certainly.
It is. Yeah, great. Thank you. Well, one of the ones I asked Lord Mingenish this is, what is your favourite quote or your favourite book, or both?
Well, I don't have a favourite quote as such, but I do have a favourite motto, and it's this: be kind. So far as a favourite book is concerned, it changes, perhaps daily, but a long-term favourite has been The Great Gatsby. I think its depiction of America at that time is almost perfect, and the prose and the style, the characters, the story, and perhaps as an added bonus, it's relatively short, but it's a book that you can read and reread, each time deriving more pleasure and more insight from it.
And is that a book that you do revisit quite a lot?
I do. My daughter, who studied English at university, didn't like The Great Gatsby at school and railed against it. But then she read it again much later and said that she understood why I liked it as well. And it's become one of her favorites.
Well, I'm going to own that book, and I have to confess that I have never actually read it. And that's terrible to say,
Now,
but I will now do so.
I direct you to do so, Alan.
Well, I'm happy to do so, and I'll provide you with feedback on it. I look forward to doing it because, as you say, it does have the real added benefit of being fairly short. Because obviously some books can just be it can be a bit overwhelming to even get started. So I will definitely do that. Another question we have is, at Hey Legal, we're involved in an initiative to launch legal careers in Scotland. And so that invariably means that we are trying to assist students and those that are completing the law degree and diploma, and people who are just starting their careers. So what advice would you give to lawyers who are just starting out in their legal career?
Well, I'm going to answer that slightly obliquely. I'm not going to give my answer just when people start their legal career. I'm going to go back slightly, because it seems to me that there's this rush to go into the law, but actually the law is about people. The law is about understanding their difficulties and problems. And rather than become an intern in a law firm when you're a student or after you leave school, it seems to me it's much better to work at standard occupations. That is, to work on a checkout, to work in a bar or restaurant, to garden or whatever, but just to find out what the texture of life is like and that will serve you very well in the conduct of your practice in your career in the legal profession.
Yeah, so don't stay in a silo, don't stay in a legal world and just simply have that experience to draw upon.
That puts it perfectly.
Yeah. So can I ask then, did you yourself do any interesting jobs prior to commencing your legal career?
Well, back in the early 1970s, when I was a law student, I worked in a tobacco farm in Ontario,
All right.
picking the tobacco. And if ever I'd had an inclination to smoke, that certainly deterred me for my lifetime.
So what was that like doing that job? And
Well, it was very interesting because half the people working on the seasonal tobacco harvest were British students, and the other half were French Canadians who worked the lumber camps in the winter. And they were two different tribes completely.
hmm. And what was it that put you, well, delighted it did put you off smoking, but what in particular was it that made you?
It was nicotine on your face, hands, clothes, nicotine everywhere.
Is that right? Doesn't sound appealing.
It was good fun. It was an interesting job, and it gave me money to travel around North America.
Yeah. And you do learn so much. I mean, that again, we've done Hey Legal Quiz and we've always asked everyone taking part as to what was their first job. And invariably, later when they're asked about, inspiring colleagues and people in the legal um, sector, they are referenced. But obviously, the life experiences they've gained in early formative years and in other roles as well out with the law really, really assist their career overall and their human experience, obviously.
Yes, I think that law is about people, and unless you understand people, you are not going to enjoy or excel at the law.
Mm, mm. Well, I suppose that then brings me on to this question, which is if you hadn't pursued a career in the law, what other profession or area of work would you have considered?
Well, after I did my solicitor's apprenticeship, I spent 9 years as an academic. I was a lecturer in the law school at Edinburgh in Old College, and I've always enjoyed academic work. So if it wasn't law and if I'd been good enough, I would like to have been a historian.
Hmm. Any particular um, type of history or period that you were interested in?
I'm drawn to the 30 Years' War. I'm not sure why, but it's just
Mhm.
always struck me as a period when there were convulsions in Europe, and it would be so interesting to study.
So when you were in academia, so you then came to the decision that you're going to go into private practice?
Well, I moved from uh, being a law lecturer to becoming an advocate. Yes.
And how did you feel about that?
Well, I just think you need new challenges in life. I mean, people say that if you move in your career, you put down new roots and you send up fresh shoots. And I think that's true. So one shouldn't be static for too long.
And did you then, so was it at that stage that you were then starting to make your first appearances in courts?
Yes. And like everyone else, I got biffed around in courts by judges, but that's the way you learn.
Yeah, absolutely. That is there's nothing can replicate that other than going in and trying to articulate an argument and then very quickly finding out its flaws.
They can be exposed. And it also means that the next time you have a court appearance, you do go that extra mile because you don't want to repeat the bad experience.
Yeah, absolutely. And it brings rigor to your thinking because it's an absolute necessity to do so because you just cannot be ill prepared for that moment when you're trying to articulate an argument in that forum.
Yes. But the great thing about the law is it's a very collegiate profession. And one truth about the law is that it's always more easy to answer your friend's problem than it is to answer your own.
Yeah, absolutely. And although at times I do recall perhaps asking questions as to whether or not a point should be taken in the common room, asking a question about whether a point should be taken at 2 o'clock, and you can get quite a lot of enthusiastic responses as to what you should do. But then when you find yourself on your feet trying to argue it, it's a very different proposition. You know,
Yes.
yeah. But it's
One tip that I would pass, and maybe others have passed it too, is that just speaking out loud the problem and speaking out loud your answer, somehow your ears turn out to be very accurate instruments.
mm,
And just articulating what the point is and what the proposed solution is can crystallize matters and make you aware of whether it's a good or a bad point.
mm. No, that's very wise, because it can very often be the case, and such as the short time scale that you have to turn, to consider a point and to argue it, that you are essentially saying it for the first time in real time within the court environment. And if the opportunity is there to do some form of preparation around it, trying to actually to articulate it shows you where the problems will lie, no doubt.
Yes,
You know,
absolutely.
yeah. Well, it's been an absolute pleasure to talk with you, Lord Woolman. Um, it's very kind of you to take the time, and it will be very interesting to see what lies ahead with the tribunal system in Scotland, and how it, I suppose, takes advantage of the opportunities that we have now. Uh, we've almost lived through an experiment, really, and continue to do so. And going forward, hopefully the rights of those that are going to be upheld in these tribunals are enhanced by the changes that have taken place.
Thank you, Ali, for the invitation. I've greatly enjoyed our discussion.
Thank you very much, Lord William.